6 days after giving birth by emergency C-section, I walked into a Boston courtroom still wearing my hospital bracelet. My husband looked the judge in the eye and claimed he couldn't support our newborn because he wasn't sure she was his. What he didn't know was that his own signature was already sitting inside a sealed DNA file on the judge's desk. And before this case ended, the court would discover he hadn't just denied his daughter. He had spent months using his own company to convince the world I was an unstable mother. My name is Rosalind Mercer Vale, and this is how the man I trusted tried to erase both me and our child. Chapter 1, 6 Days Old. 6 days after my daughter was born, I walked into Suffolk County Probate and Family Court with a hospital bracelet still around my wrist and a fresh incision pulling beneath my coat. My name is Rosalind Mercer Vale. I was 35 years old, and Iris Evelyn Mercer Vale weighed just over 6 pounds. She slept against my chest as if the world had not already begun arguing over who she belonged to. Every step hurt. I kept one hand beneath the blanket around Iris and the other close to my abdomen. The doctors had delivered her by emergency cesarean section after severe preeclampsia sent my blood pressure into dangerous territory. I had spent the previous night trying to sleep in 40-minute stretches while learning how to feed a newborn without pulling at the staples beneath my skin. My attorney, Maeve Callahan, had asked for the hearing to be postponed. Damien refused. I knew I was exhausted. He knew I had been discharged less than 24 hours earlier. He knew that if he pushed hard enough, I might sign anything just to take my baby home and close my eyes. That was why he chose that morning. The hearing was not the final divorce trial. It was supposed to establish temporary rules while the case moved forward. Who could live in the brownstone? Who would pay for Iris? Whether Damien would be recognized as her father? How and when he could see her. What either of us could say publicly. Temporary orders sounded harmless until I read what Damien wanted. He wanted me out of the Back Bay brownstone within 30 days, unless I accepted a limited right to stay there under terms he controlled. He wanted to delay support until paternity was confirmed again. He wanted flexible access to Iris whenever his schedule allowed. He wanted me prohibited from discussing our marriage or Vale Arc Health Systems in public. Damien Vale was already seated when I entered. At 42, he looked exactly like the man business magazines like to photograph. Dark suit-controlled posture, silver watch, no visible panic. His attorney, Martin Keene, sat beside him with several organized folders. Sabrina Bell sat directly behind them. She was 37 and Vale Arc's vice president of brand strategy. She had also been sleeping with my husband since the previous fall. She was not permitted to sit at counsel table, but she positioned herself close enough to whisper to Damien and far enough back to monitor the reporters. Her phone never left her hand. Damien did not stand when he saw me. He did not ask whether I was in pain. He did not ask whether Iris was healthy. He looked at the blanket covering his daughter and said to Martin loudly enough for the nearest benches to hear that he would not accept financial responsibility until paternity had been verified through an independent process. I felt Iris move against me. I tightened my arm around her and said nothing. Judge Helena Crawford entered a few minutes later. She was 59, composed and visibly displeased when she noticed the newborn in my arms. She asked why the hearing had not been postponed. Martin said the matters before the court were urgent. Housing, financial support, and access to the child could not remain unresolved. Maeve stood carefully. She explained that I had been discharged less than 24 hours before Damien rejected the medical continuance. The judge looked at Damien. He did not apologize. He said he wanted clarity. He said I was emotionally vulnerable after childbirth. He said there were concerns about stability. He said he wanted to protect Iris from being used in a dispute. He said Mercer House should not be allowed to interfere with the operations of Vale Arc. That was how Damien worked. He never called me irrational. He said I was under strain. He never called me unfit. He said there were concerns. He never said Iris was not his child. He said paternity remained unresolved. He could wrap cruelty in professional language until it sounded almost responsible. Martin began with the house. He explained that Damien was willing to allow me to remain in the brownstone for 12 months, while the parties determined how the property would be divided. I looked across the room at my husband for the first time. I said I did not consent to being temporarily allowed to live in a house he did not own. The room went still. Maeve placed the deed and the relevant trust pages before the judge. Mercer House Residential Trust had purchased the Back Bay brownstone in 2014 for $2,350,000. That was 2 years before Damien and I married. The trust granted me long-term occupancy rights. Damien had no authority to sell the property, mortgage it, or order me to leave. Martin was not surprised that a trust existed. He was surprised by what the trust actually said. Damien had told him the house was family property used as the marital residence. He had apparently left out the part where his name had never carried an ownership interest. Judge Crawford did not make a final ruling on the classification of the property. She said that would require fuller review. She did issue temporary orders. Neither party could transfer, sell, or encumber the brownstone. I would have exclusive occupancy for 90 days while I recovered and cared for Iris. Damien could not enter without written permission or another court order. He had arrived expecting to decide how long I could remain in my own home. Before the morning was half over, he had lost the right to enter it. His expression barely changed, but Sabrina stopped typing. The judge moved to paternity. Martin requested testing through a laboratory approved by the court. Maeve said I had no objection. Then she said the issue was not whether Damien was Iris's father. The issue was why he continued speaking as though he did not already know. She did not open the sealed report. Instead, she presented the consent form Damien had signed on March 7th, and the notice showing that the resulting report had been delivered to both legal offices on March 17th. Martin confirmed that his office had received it. He explained that Damien had insisted on postnatal confirmation before accepting a permanent legal position. What surprised Martin was not the existence of the report. It was hearing his client publicly describe paternity as unresolved after receiving it. Damien asked for time to review the documents. Judge Crawford made no final finding. Before Maeve could continue, Iris began to cry. The sound was small, at first then sharp enough to fill the courtroom. I tried to stand, but pain caught beneath my ribs and pulled me back into the chair. A court officer came over and led me to a private room where I could feed her. Once the door closed, my hands started shaking. Maeve helped me settle into the chair without touching the incision. I told her that if Damien had looked at Iris once and asked whether she was all right, I might have weakened. Maeve crouched beside me. She reminded me that we were not there to prove Damien had been a bad husband. We were there to protect Iris before he could define her as an unresolved claim. My phone vibrated on the table. The email was from Leah Morgan, a health and business reporter. She asked whether I wanted to respond to concerns regarding my postpartum mental condition, my ability to care for a newborn, and my capacity to manage family assets during a period of instability. I had never been declared incapable. I had never experienced the mental health episode the email implied. The wording was almost identical to Damien's language in court. Emotionally vulnerable. Concerns about stability. Questions about judgment. I looked down at Iris while she fed, unaware that adults were already building a public story around her. The hearing was only one part of Damien's plan. Another version of me was being prepared for the press. When I returned to the courtroom, Iris was asleep. The sealed DNA report remained on the table in front of Maeve. Damien believed the most dangerous thing inside that envelope was a number. The number would only prove that he was Iris's father. The rest of my records would prove that he had known it before he decided to turn his 6-day-old daughter into a strategy. Chapter 2, the record he could not rewrite. 2 months earlier on Valentine's Day, Damien had already begun rehearsing the version of our marriage he planned to sell. I was standing in this kitchen of the Back Bay brownstone, almost 27 weeks pregnant, slicing an apple because it was one of the few things I could keep down before noon. Damien walked in while speaking to an investor. He ended the call, set his phone beside the coffee machine, and told me our marriage was no longer working. His tone was calm. That made it worse. He said he wanted a clean separation. He said he would cover my medical expenses through the delivery. He said I could remain in the house for 12 months while I found another place. Then he said financial support for the baby would depend on confirmed paternity. I stopped cutting the apple. We had spent years trying to have a child. Every appointment, every blood test, every disappointment had happened inside the same marriage. I asked why paternity had suddenly become uncertain. Damien adjusted the cuff of his shirt. He said complicated divorces required verification. That sentence told me he had already spoken to lawyers. He was not opening a discussion. He was delivering a plan. I did not throw the knife or demand a name. I asked when he intended to move out. He looked surprised by the question. That afternoon, I called Maeve Callahan. By then, I had known Damien for almost 12 years. We met in 2013 at a hospital fundraiser in Cambridge. He was 30, brilliant, exhausted, and nowhere near wealthy. He had built an early model that could identify patterns associated with sepsis before a patient's condition became obvious. The technology was promising. The clinical path was not. Damien understood code, but he did not understand hospital ethics committees, research governance, or why no serious health system would hand sensitive data to an ambitious stranger with a laptop. I did not build Veil Arc for him. He built the product. He worked impossible hours, recruited talented people, and convinced investors to take risks. What I did was help him understand the doors he kept trying to force open. I introduced him to experts in de-identified clinical data. I explained how research agreements worked. I connected him with physicians who would challenge his assumptions before patients paid for them. VeilArc Health Systems was formed in 2015. The following year, Mercer House invested $6,800,000 through an independent fund. My name was not in the press release. I preferred it that way. At first, Damien thanked me privately. Later, he began describing every introduction as something he had earned alone. I let him. I thought loyalty meant never embarrassing the person you loved by reminding him how much help he had received. What I was really doing was making myself smaller so he could feel self-made. A week after he asked for the divorce veil, ARC released a statement saying Damien and I had been living separately since October 2024. That was false. He still slept in the brownstone until February 21st. The front door camera showed him entering every night. His security schedule listed the address as his residence. His meals were delivered there. He took investor calls from the upstairs office. Maeve saved everything. She told me not to challenge the statement publicly. Damien wanted an emotional response. If I shouted loudly enough, he would point to the shouting and call it proof. So, I stayed quiet. Back in the courtroom, Maeve finally opened the sealed report. She handed copies to Judge Crawford and Martin. The results stated that Damien Veil was Iris's biological father, with a probability of 99.99996%. The report included his signed consent, the documented chain of custody, the laboratory certification, and proof that both legal offices received it on March 17th. Judge Crawford looked at Damien. She asked whether he disputed signing the consent form. He said no. She asked whether he denied that his attorneys received the report. He said he had concerns about whether a prenatal test should determine a permanent legal obligation. Martin spoke carefully. His office had received the report, but Damien had instructed him that a postnatal test would still be requested. The judge allowed another test through a court-approved laboratory at Damien's expense. Then she said the existing report was still powerful evidence that he had known the likely truth for more than 2 months. Behind him, Sabrina leaned forward. She asked him why he had told her the result was inconclusive. Her voice was low, but I heard it. Damien did not turn around. For one brief second, Sabrina looked less polished. She had been lied to. That did not make her innocent. She knew I was pregnant. She knew he was married. She had still come to court to watch him question his own daughter. Maeve moved to temporary support. Damien's financial filing presented him as a man with a high valuation and surprisingly modest income. Most of his wealth, Martin argued, was tied up in VeilArc equity. Maeve requested discovery into his base salary, annual bonus distributions, liquidity events, and personal expenses paid through the company. Judge Crawford ordered temporary child support of $18,500 a month. She explained that the amount reflected Damien's actual resources, the medical and childcare needs of a newborn, and the standard of living available to both parents. The money belonged to Iris's care. It was not a reward for me. Then Maeve presented the hospital record. Dr. Annika Rios had submitted an affidavit confirming that I arrived at the hospital on the evening of May 17th with dangerously high blood pressure. At 8:11 p.m., I texted Damien that the doctor wanted him there. At 11:38 p.m., I told him my condition was getting worse. At 2:17 a.m., I told him I was being taken into surgery. At 3:08 a.m., after Iris was born, a nurse helped me send the final message. All 4 had been delivered. The visitor log showed Damien never entered the hospital. Maeve placed one hotel invoice beside the record. Then, one photograph. Damien and Sabrina had been at the St. Regis Boston from May 17th through May 19th. In the photograph, they were seated at the hotel restaurant. Damien said he had been managing an urgent investor issue. He said he believed I was receiving appropriate medical care. Then he claimed his legal team had advised him to limit direct communication with me. Martin looked at him. He told the judge that no one in his office had advised Damien to ignore a medical emergency or the birth of his child. Judge Crawford asked Damien why he had not answered even once. For the first time that morning, he had no professional phrase ready. The silence lasted longer than any explanation could have. The judge granted me temporary primary physical custody. Damien would see Iris twice each week at Brookline Family Contact Center for 90 minutes while a parenting evaluation was completed. She made clear that the order was not punishment for adultery. It was based on the fact that Damien had no established relationship with Iris, had missed her birth, and had continued to use paternity as a public question after receiving the report. The medical and DNA records were sealed. Neither of us could discuss Iris's health paternity or custody with the press. After the hearing, Margaret Vale called me. She was 67, a retired pediatric nursing director, and once the closest thing I had to a second mother. She said Damien told her I had ambushed him with my family trust. She asked whether I intended to destroy Valark to punish him. I told her to ask her son for the consent form dated March 7th and the result dated March 14th. Margaret went quiet. She admitted Damien had never told her the test already existed. What hurt was not only that she doubted me. She had accepted doubt about her own granddaughter because believing Damien was easier. That evening, Maeve sent me another document. It was a custody memorandum dated May 2nd. It described me as emotionally volatile, socially isolated, financially dependent, and likely to use the newborn as leverage. Financially dependent. Damien had lived in a trust-owned house. His company had grown through doors my family helped open. He knew exactly what I had contributed. He still wrote me as if I had never built anything. Maeve had checked the metadata. The document had not been created at Martin's law office. It had been drafted through a Valark brand strategy account. The first listed author was Sabrina Bell. The final approval belonged to Damien Vale. Chapter 3, The Story They Wanted to Sell. Seeing both names and the metadata changed the shape of the betrayal. Until then, I had thought Damien was using Sabrina to manage the fallout from our marriage. The document proved something worse. They had used Valark to design the version of me they wanted the court, the press, and the public to believe. I returned to the brownstone with Iris asleep in her car seat and the custody memorandum saved in 3 separate locations. The house was quiet, but quiet did not feel safe yet. The nursery still looked unfinished. The crib Damien had promised to assemble sat inside its shipping box against the wall. He had ordered it after our 20-week ultrasound and spent weeks telling me he would put it together when work slowed down. Work never slowed down. Neither did his excuses. I called June Holloway, a 58-year-old contractor who owned a small interior repair business in Jamaica Plain. She arrived the following afternoon carrying a tool bag and a paper cup of coffee. She glanced at the unopened crib, then at Iris sleeping in the bassinet beside me. "Someone leave a promise in a box." I nodded. June opened the packaging without asking anything else. She assembled the crib, tightened the rocking chair, and checked the wall anchors on the changing table. When she finished, she rested one hand on the crib rail. A safe home sometimes starts with finishing what somebody else promised and left behind. Then she packed her tools and left. By the next morning, Damien's public story had begun to spread. A business website published an article about an unnamed heiress experiencing postpartum instability, who was threatening a medical technology company with hundreds of employees. A cable segment asked whether a bitter divorce could jeopardize Valark's access to clinical research data. No one used my full name. They did not need to. People in Boston's hospital and donor community knew exactly who the story described. Messages arrived from people who had attended our wedding, sat at Mercer House fundraisers, and accepted invitations to our home. Do not destroy the company because your marriage failed. Think about the employees. Do not use your daughter as leverage. Damien's framing was working. He had become the responsible founder, protecting a company and a child. I had become the wealthy emotional wife, using both as weapons. Leah Morgan called before publishing her own article. She was not warm or apologetic. She was professional. "I received a set of talking points from someone close to Valark," she said. "I am giving you an opportunity to respond. What do they say?" "That you have a history of emotional instability, that you threatened to withdraw Mercer data if Damien did not reconcile, and that you intend to use your daughter to gain control of Valark. All 3 are false. Can you prove that?" "Yes." Maeve, who was listening from the other side of my kitchen table, shook her head before I could say more. I understood. Proving everything to Leah would mean opening sealed records and attaching Iris's name to the scandal before she was old enough to hold up her own head. Maeve drafted a statement that was 3 sentences long. Rosalind Mercer Vale is focused on her daughter's health, her own medical recovery, and the pending legal process. The child's records have been sealed by the court. Those matters will not be litigated through the media. I hated how little it said. I wanted to release the DNA report, the hospital messages, the hotel invoice, and the custody memorandum. I wanted every person who had called me vindictive to see what Damien had done. Instead, I approved the statement. Winning the internet for one day was not worth making Iris searchable for the rest of her life. Maeve sent preservation notices that afternoon to Damien, Sabrina, Vale Arc, and the entire brand strategy department. The notices required them to preserve emails, text messages, draft statements, custody documents, edit, histories, expense reports, hotel reimbursements, and all associated metadata. Martin responded within hours. He accused us of converting a family dispute into a corporate attack. The Vale Arc board issued a statement supporting Damien and declaring that there was no evidence company operations had been affected. That was the first moment I understood how difficult the next part would be. The board did not want the truth. It wanted stability. Damien had built a company worth hundreds of millions of dollars. The people around him had strong financial reasons to describe every accusation as a private marital conflict. I had not won anything yet. 2 days later, my uncle Jonah Mercer called a meeting at Mercer House Foundation in Cambridge. Jonah was 61 and served as the foundation's independent chairman. He had known Damien since before Vale Arc had an office, but he never confused familiarity with trust. He placed a contract summary on the table. Mercer Clinical Research Network provides roughly 31% of Vale Arc's validated clinical data, he said. I know. Ending the agreement without a structured review could affect 184 employees, 27 hospital partners, and active sepsis detection programs. I am not asking you to end it. What are you asking? Open an ethics review. Jonah studied me. In your role, I recuse myself from every decision involving Vale Arc. He leaned back. That removes the easiest argument Damien could make. That I am using patience to punish my husband. You are. I am not his wife in this room. I am a beneficiary with a conflict. Jonah nodded once. He opened a thin folder and passed me a letter written by my grandmother Evelyn before her death in 2021. Most of it concerned governance. One line had been underlined. Family assets exist to protect people, not to control them. I folded the letter and returned it to Jonah. Damien's consequences would have to come from what he had done, not from my anger. That evening, Margaret Vale appeared outside the brownstone without warning. She stopped at the gate because the temporary order prohibited Damien or anyone acting for him from entering without permission. I stepped onto the front walk while Iris slept inside with a postpartum nurse. Margaret looked older than she had at Christmas. I want to see my granddaughter, she said. You called her leverage. I said you were using the situation against Damien. The situation is Iris. I am trying to protect my son. Protecting Damien cannot mean helping him deny his own daughter. Margaret's mouth tightened. You have put me between two sides. Iris is not a side. She is a child Damien knew was his. Margaret looked toward the house. I did not open the gate. She left without seeing Iris. The next morning, Sabrina came to Maeve's office with her own attorney, Courtney Blake. Sabrina looked controlled, but there were shadows beneath her eyes. Courtney did most of the talking. They confirmed that all original files and metadata had been preserved. They were not yet prepared to release everything. Sabrina finally looked at me. I wrote the talking points. I know. I edited the custody memo through my Vale Arc account. I know that too. Damien gave me the information. You still chose to use it. Her expression hardened. He told me paternity was uncertain. He said Mercer House was a charitable trust with no meaningful assets. He said you were using the pregnancy to keep him from leaving. And you believed him. Yes. Why did you believe a man who was lying to his wife would tell his mistress the complete truth? Sabrina had no answer. Courtney placed a document on the table. Mr. Vale recently asked my client to sign an affidavit, stating that the communication strategy was developed independently by her. Maeve read the first page. He wants her to take responsibility. Sabrina's voice became quieter. He wants me to say he never approved any of it. I felt no satisfaction. Sabrina had participated willingly until the consequences reached her. The truth you tell now does not erase what you knew. Then I said, you knew I was pregnant. I know. Courtney gathered the document. We will contact you after we complete our review. They left without turning over the messages. That night, Margaret called again. Her voice sounded different. I found a voicemail from Damien, she said. When March 19th, 5 days after the DNA result. Margaret played it through the phone. Damien's voice was calm. He said he needed to control the story before Rosalind used the child and Mercer House against him. When it ended, Margaret did not speak for several seconds. The first time I heard it, I thought he was frightened, she said. Now I hear that he knew. He knew Iris was his, and he still called her a tool you might use. Will you send it to Maeve? Yes. She did not ask to be forgiven. She did not ask to see Iris. For the first time, she simply did the necessary thing. The following afternoon, Maeve called me while I was rocking Iris beside the newly assembled crib. Sabrina signed the preservation agreement, she said. Courtney is releasing the files. Is it enough to prove the smear campaign? It is more than that. At Vale Arc, Priya Desai, the company's 43-year-old chief clinical compliance officer, had found the custody memorandum on the corporate server. She found employee hours charged to the media strategy. She found St. Regis expenses classified as investor relations. Maeve paused before continuing. Damien did not only use Vale Arc to attack you. He used company money, company employees, and company systems to do it, then tried to hide it from his own board. Chapter 4. When the company stopped protecting him. By the next morning, the problem was no longer whether the smear campaign existed. The problem was how deeply Damien had buried it inside the company he claimed to be protecting. Courtney Blake released authenticated copies of Sabrina's messages, emails, draft statements, edit histories, and metadata to Maeve. The documents showed that Damien had known the prenatal DNA result before he approved the custody memorandum. He instructed Sabrina to keep using the phrase paternity uncertainty. He approved language describing me as unstable if I refused to sign his proposed settlement. He mentioned a producer at Northlight Media who owed him a favor. In one message, Sabrina asked whether the DNA results should be disclosed before the temporary hearing. Damien answered with 6 words. It stays buried unless useful. Another thread showed him telling Sabrina that if the media strategy became public, she would need to say she developed it without his knowledge. He had not only lied to her, he had prepared to leave her holding the evidence. Sabrina's cooperation did not make her innocent. She had known he was married. She had known I was pregnant. She had helped turn my recovery into a public weakness. She was helping now because the danger had finally reached her. That mattered. It did not erase anything. At Vale Arc, Priya Desai completed her internal report. 3 brand strategy employees had spent a combined 96 hours working on the campaign against me. About $74,000 in hotel public relations and consulting expenses had been classified as investor relations. The custody memorandum and media plan had been stored on Vale Arc's server. The company's risk disclosures had also failed to describe the possibility that Mercer House might review its clinical research agreement. Priya presented the findings to the board. Some directors still wanted to protect Damien. They argued that removing the founder could damage investor confidence, reduce the company's value, and endanger 184 jobs. Priya answered that those risks did not justify hiding misuse of company resources. The board hired Graham Ellis as independent counsel and formed a special committee. For the first time, Damien could no longer dismiss the matter as an angry wife making private accusations. He responded exactly as Maeve expected. He called Sabrina a disgruntled employee. He accused Priya of exceeding her authority. He said I was using Mercer House to destabilize Vale Arc. He warned that any restriction on his leadership would hurt employees and hospital partners. I remained recused from every Mercer House decision involving the company. The foundation did not terminate the agreement. It requested independent oversight, preservation of clinical data, and the removal of Damien from decisions involving Mercer partnerships, while the review continued. He could no longer use employees as a shield without someone asking who had placed them in danger. The evidentiary hearing took place on July 9th. I did not bring Iris. She stayed at the brownstone with the postpartum nurse and June's finished crib waiting upstairs. When Maeve asked whether I was certain, I told her my daughter did not need to appear in court to prove she existed. Judge Crawford reviewed the postnatal DNA result from the court-approved laboratory. It confirmed again that Damien was Iris's biological father. She also reviewed the prenatal consent form, the delivery receipt sent to both law offices, the custody memorandum, the metadata, the messages between Damien and Sabrina Margaret's voicemail, Dr. Annika Rios's affidavit, and the talking points Leah Morgan had received. Martin Keene did not argue that paternity remained unresolved. He limited his objections to authentication context and procedure. When Damien took the stand, he admitted that he had received the prenatal result. He said he had concerns about chain of custody and wanted a second test before accepting permanent obligations. Maeve opened one of the message threads. You never mentioned chain of custody to Ms. Bell. Damien looked toward Martin before answering. I was not required to explain every legal concern in a private message. Maeve read the line he had sent. It stays buried unless useful. She set the page down. What did useful mean? It referred to litigation strategy. Judge Crawford leaned forward. Useful to whom, Mr. Vale? Damien paused. To the legal process. The judge did not look convinced. Maeve displayed the edit history of the custody memorandum. The phrase unresolved paternity had remained in the document after Damien received the result. The paragraph describing me as emotionally volatile had been expanded the same day Sabrina contacted Northlight Media. The claim that I was financially dependent had been approved by Damien himself. The record did not show caution. It showed construction. Sabrina testified under an agreement negotiated through Courtney. She admitted knowing Damien was married and knowing I was pregnant. She admitted helping create the media strategy. He told me the test was inconclusive, she said. He told me Rosalind had no meaningful assets outside a small charitable trust. Maeve asked whether Damien had discussed the brownstone. He said it was marital property under his control. And the pregnancy? He said Rosalind was using it to stop him from leaving. Sabrina's voice stayed steady until Maeve asked about the affidavit. I wanted me to say the campaign was my idea, she said. He said the board would forgive a communications mistake. They would not forgive a founder using company resources against his wife. I did not look at her as if she had rescued me. She had simply stopped helping Damien bury the truth. Margaret testified only long enough to authenticate the voicemail. She explained when she received it and why she had kept it. I believed my son because I did not want to believe he could use a child this way, she said. She did not ask the judge for sympathy. She did not turn toward me. That restraint was the first respectful thing she had offered since Iris was born. Judge Crawford issued her ruling that afternoon. She found that Damien had deliberately maintained public uncertainty about paternity despite strong evidence that he was Iris's father. She also found that he had participated in a communication strategy that threatened the child's privacy and could influence the custody process. I retained temporary primary physical custody. Damien's visits at Brookline Family Contact Center would continue while the parenting evaluation remained open. He could not bring Sabrina public relations staff or members of the press to any visit. Iris's medical and DNA records would remain sealed. Damien was ordered to stop making unsupported statements about my mental health. Financial discovery was expanded. My exclusive occupancy of the brownstone was extended through final settlement. Before ending the hearing, Judge Crawford looked directly at Damien. A child is not a negotiating device. A mother recovering from childbirth is not material for a communications campaign. Outside the courtroom, Damien caught up with me near the elevators. Do you actually want to destroy Vale Arc? I did not put my marriage on the company server. You knew what Mercer House could do to us. I recused myself. You hid who you were. I stopped walking. I never hid my family, the trust, or my work. You decided which parts of me were worth noticing. I left before the conversation could become another performance. 2 weeks later, the special committee announced temporary action. Damien retained his shares and the title of founder, but stepped away from the operating CEO role during the review. A governance chair was appointed. Priya took oversight of clinical partnerships. Mercer House continued its agreement under stricter supervision. There were no mass layoffs. Damien did not lose everything. He lost the ability to act without being questioned. Sabrina notified the board that she intended to resign. Margaret sent me a letter of apology, but she did not ask to see Iris immediately. Then, after one of Damien's supervised visits, a message appeared in the court-approved parenting application. He did not apologize. He did not mention Vale Arc, the trust, or the hearing. Does Iris always hold someone's finger when she sleeps? I looked across the nursery at my daughter resting in the crib June had assembled. It was the first question Damien had asked about Iris that was not connected to paternity money or strategy. I did not mistake one correct question for change. A single moment of attention could not erase months of deliberate harm. But for the first time, he had asked about his daughter, instead of asking what she could cost him. Chapter 5, What He Could Not Take. By October, Damien had learned that asking about Iris was easier than understanding what she needed from him. He completed the parenting evaluation, attended 10 supervised visits at Brookline Family Contact Center, finished an infant care course, and began individual counseling. Nora Bennett documented each session. He arrived on time. He followed instructions. He stopped questioning paternity. He learned how to prepare a bottle without checking his phone every 30 seconds. He began remembering when Iris usually slept, and which position calmed her when she became restless. The reports also noted that he often asked how he was being evaluated. He wanted to know whether a good visit would help expand his schedule. He wanted to know what the court would think. He was beginning to perform the right actions. He had not yet learned to stop watching for the score. I did not confuse progress with redemption. By then, I had physically recovered from the surgery, although certain movements still reminded me of that week in May. Iris was more than 5 months old. She laughed when I kissed beneath her chin and had discovered that her own feet were endlessly fascinating. Valar continued operating under the governance chair. Priya Desai reported that the hospital partners remained in place because the company had separated Damien from clinical partnership decisions and accepted independent oversight. No mass layoffs followed. The 184 employees Damien had used as a shield did not lose their jobs because I refused to make innocent people pay for what he had done. The governance review reduced Valark's internal valuation from roughly $940 million to about $785 million. Damien still had money. He still owned shares. He still had the title of founder. What he no longer had was the ability to treat every room as though no one else had the authority to question him. The final settlement conference took place on October 28th. Maeve and I arrived early. Damien came with Martin without Sabrina and without a public relations advisor waiting outside. The brownstone was formally confirmed as property of Mercer House Residential Trust. Damien released every claim to ownership, occupancy, appreciation, or control. My separate interests in Mercer House remained outside the marital estate. His Vale Arc equity remained his, but the full value distributions, compensation, and liquidity rights were disclosed before the financial terms were completed. I did not ask for control of Vale Arc. I had spent too many months proving that I was not trying to seize his company to take any role in it now. Damien funded an irrevocable support trust for Iris with $2,400,000. The money could be used for medical care, education, childcare, and developmental needs. It was not an account I could spend from whenever I wanted. An independent trustee would review distributions and maintain records. The trust belonged to Iris's future, not to either parent's pride. Child support was adjusted according to Damien's salary distributions and future equity liquidity. I retained primary physical custody. We shared structured legal decision-making, but I held final authority over medical care while Iris was young if we reached an impasse. Damien's visits could gradually move outside the contact center after 6 additional months of consistent compliance. His access would expand through behavior, not promises. Neither of us could use Iris's name, image, medical history, or court records in personal publicity or company communications. For the first time since Damien asked for the divorce, every important rule existed in writing. Sabrina formally resigned from Vale Arc. She moved to New York and accepted a lower-level position at a smaller agency. Several weeks later, Courtney informed Maeve that Sabrina had donated $50,000 to a digital evidence preservation fund. I did not return the money. I did not send her a personal thank you. She had participated in trying to erase me, then helped preserve the proof when Damien attempted to erase her. The donation did not make her innocent. It was simply one consequence she had chosen to carry. Margaret began seeing Iris at the brownstone under boundaries we agreed on in advance. During the first visits, a postpartum nurse or Maeve's family coordinator remained nearby. Margaret did not ask me to forgive Damien. She did not bring messages from him or suggest that a child needed married parents more than she needed safe ones. One afternoon, while Iris slept in Margaret's arms, she spoke without looking up. It took me too long to understand the difference between loving my son and helping him avoid consequences. I watched her adjust the blanket around Iris. She needs a grandmother who understands that difference. Margaret nodded. That was enough for the moment. After the settlement papers were signed, Damien caught up with me in the courthouse hallway. There were no cameras, no reporters, no Sabrina watching his posture. He stood several feet away and asked whether Iris looked like him. Sometimes she frowns like you. A brief smile crossed his face and disappeared. I am sorry, Rosalind. I waited. I was afraid of losing the company. My reputation. Control of everything I built. You did not make one frightened mistake. He lowered his eyes. Al built a plan where I had to become unstable, so you could look reasonable. I know. Hearing him admit it did not repair anything. It only removed one more place for him to hide. Knowing does not change what happened. It only changes what you choose to do next. He looked toward the courtroom doors. Will she know me as her father? That depends on who you become when no one is watching. I walked away before the conversation could turn into forgiveness he had not earned. On December 12th, Mercer House opened the Iris Mercer Maternal Advocacy Center in Cambridge. The center had its own independent board and offered emergency legal support, postpartum mental health care, digital evidence preservation, custody guidance, financial counseling, and transportation for women forced to move between hospitals and courtrooms. I did not build it because I believed every woman should fight the way I had. I built it because most women did not have what I had. They did not have a protected home. They did not have a family trust. They did not have Maeve. They did not have the money to preserve every record while someone more powerful shaped the public story. At the opening, I kept my remarks brief. No mother should have to choose between recovering and protecting herself. No child should become the battlefield for someone else's reputation. After the guests left, I sat with Iris in the center's childcare room. Winter lights spread across the floor while she pulled at the sleeve of my sweater. My phone displayed a new report from Nora. Damien had completed his 14th parenting session. He arrived 18 minutes early. He brought the correct formula. He remembered Iris's nap schedule without being reminded. I saved the report to the custody file. I did not feel my old love returning. I did not feel that I had defeated a man. I recorded one correct action performed without an audience. That was how responsibility worked. Not through speeches, not through apologies made in courthouse hallways, through small choices repeated when no one applauded. I looked at Iris and finally understood that she had never been the problem Damien needed to solve. She was the boundary that taught me to stop disappearing. He could not take the brownstone. He could not take my name. He could not erase what I had built. Most importantly, he no longer had the power to write the future for either of us. After everything Damien did, was I right to leave the door open for him to become Iris's father? Share your thoughts in the comments and stay with the channel for more stories about betrayal, evidence, and justice.